All right. Welcome. This is the second session of online contracting videos. And our topic today, let's start our risk allocation terms. We're going to look at exculpatory and indemnity clauses and waivers of liability. And let's remind ourselves why we're doing this as we start. So here's our plan, right? Our plan is to first look at offline standard form contracting, then compare modern online contracting. And when we were discussing this in the first video, we noted that there are, we can count them 1, 2, 3, 4, 6 doctrines we're going to consider. And the first doctrine that we're going to look at to understand offline contracting are clauses that shift liability. Right? Exculpatory indemnity clauses, waivers of liability. Our underlying idea is to see what constrains, what limits the clauses in these contracts, because as we mentioned last time, everybody knows people don't read them, wouldn't understand them if they did read them. So what can a business put in a contract that it knows people won't read and won't understand? There must be some limits, there are limits, and we're working our way through the limits of traditional offline standard form contracting. That said, the emphasis on offline standard form contracting, we'll use some examples from online contracting in this particular video, just because it's easier to go get the sample terms off the internet. But everything we say is exactly the same for offline contracting. We're just making use of the fact that we have some contracts online that we can easily copy and we all can look at and that we all experience. So that said, let's get started. So we're going to start with exculpatory clauses. And an exculpatory clause is just a clause that says a person won't be liable for the consequences of their negligence. I was just changing that clause before we started to make it a little more readable, and in making my change to make it more readable, I left out the crucial part. There we go. That makes much more sense, right? So exculpatory will not be liable for the consequences of your negligence, right? Exculpatory just means excuse. So we'll start with an example. A good example, the banking case of Patco versus People's United Bank. I didn't assign that to read. Let's keep the reading down to a reasonable amount, and I can just tell you everything you need to know about that case, right? So Patco was a small business, and it used e-banking for its weekly payroll, right, through People's United Bank. Now, so Patco gets hacked, right? So the story starts with Patco, not with the bank. Patco gets hacked, and the hacker puts a keylogger on the computers. The keylogger records every keystroke the computer makes, and then sends it off to the hacker. So you can use that to capture passwords and answers to security questions. So you can then pretend to be the business and go to the bank, right? And pretend to be Patco. That's exactly what happened, right? The hackers made 6 withdrawals totaling almost $600,000. So the question then in the case is, who has to bear that loss? Does the bank have to reimburse Patco for the withdrawals by the hacker from the bank, or is that Patco's problem? And is that the bank says, hey, not our problem, you're the one that got hacked, your problem. And the basic law on this is that if the bank's security procedures were commercially reasonable, the bank has no liability. Subject to one crucial qualification important for us. Right, the crucial qualification is the exculpatory clause in the contract. The bank's contract with Patco had a clause that basically says, hey, if we're negligent, it's not our fault, it's your problem, right? So But before we do that, let me change my size of, that should work better. I like a little bigger pen marker for the slide, so if you'll bear with me. Let's make sure we have it. Nope. Oh well, we'll go along with this one because it's not worth the time to me to figure out why it's doing this and make the change. Okay, so we see what it is, right? We're here, right here. Right, this is the clause. And there is law about that. Since we're doing the case, let's look at it. Right, that's the effect of Uniform Commercial Code 4A. So we'll turn to that in a second, but let's not forget the critical question. So the whole question in the case is this one down here. Were the procedures reasonable? Well, the whole question minus the issue about the contract clause, right, which is why we're interested. So the central question, were the bank's procedures reasonable? The court, the appeals court says no, right? And you'd think that then, okay, no, so the bank has to pay, but they don't say that. They stop there and just say no and say there's a further question about whether PATCO has to pay that they're not going to consider at that time. And that further question is the effect of the exculpatory clause in the bank's contract with PATCO. So we'll work all this out. Just for background, let's make sure we know what the Uniform Commercial Code is. So what is the Uniform Commercial Code? I put in the slides the explanation from the people that write and maintain the Uniform Commercial Code, the Uniform Laws Commission. And you can read their explanation at your leisure. I'll just tell you the idea. The idea is, well, look, in the United States, we have 50 states. And commercial law, especially contract law goes state by state by state. So we have basically 50, well, not basically, really, 50 different contract laws. That's a nightmare if you're a business doing business nationally in the United States, then you'd have 50 different contracting jurisdictions to comply with. And you have to make sure that you don't mess up in each of those 50 different legal regimes. Well, that's not good. And to solve that, the United States Uniform Laws Commission wrote a model law. As the quote points out in the slide, this is not a law, right? This is a model, a recommendation to the states to all adopt laws like this in a particular area for contract law, for commercial transactions, and so on. And since the states have all pretty much with very little change adopted the recommendations of the Uniform Commercial Code and the Uniform Laws Commission, then you'll see courts and courts do it, law schools do it, law teachers do it, treat the Uniform Commercial Code as if it were a national law of the United States. That's what we'll do, but you see the idea, you'll see the idea there. And you see this court quotes UCC 4A. What's the court doing quoting UCC 4A? It's not law, but everybody does it since it's been so widely adopted, right? That everybody does it, right? And here, just so you see it, is the crucial provision of Uniform Commercial Code 4A, which says, look, if the, down here in the italicized part, down here, if the security procedures are commercially reasonable and the bank followed them, right? Then the bank has no, then as far as the code's concerned, the bank has no liability, right? So our first subject to, right, the qualification that there's an exculpatory clause. So were the bank's procedures, what were the bank's procedures? So of course, so let's go back to this slide. So were the procedures reasonable? What were the bank's procedures? Did it follow them? We'll work all that out, and then we'll look at the effect of the exculpatory clause. So the bank had, People's United Bank had an excellent security system, right? You can see they purchased it from a vendor that sold security systems. The vendor installed it, told them how to use it. And it's basically exactly what a bank should be doing to be secure against fraudulent transactions. The details don't matter to us, but just worth taking a little look at them. So they use a number of different factors. Location, that's why they want to know your location from which you logged in. How often do you log in? What did you do on the system? How much money are you pulling out? Ordinary, how much money do you pull out? How much money do you put in, on a same frequency, right? What's normal behavior? And then the premium product, which Patco, which United People's United Bank had, they looked at your IP address. This is typical stuff. If you look at all these factors, then you should see a pattern of normal behavior. And then when you see something that's out of the pattern of normal behavior, you think, hey, maybe there's something fraudulent going on. So they had excellent procedures. Did they follow them? And the answer is an overwhelming no. They had them, but they didn't follow them. And if you're interested in online security, which is an interest of mine, this is all too often the scenario, right? Businesses will have excellent security procedures in place, but they don't follow them. And People's United Bank didn't follow them, right? You can see from the slide, their security system generates a risk score, right? Patco's risk scores, the system, when Patco was using the system itself to do its real banking, its risk scores went from 10 to 214. All of a sudden they're in the 790, 725, 63, 785 over a period of 6 days. Something's going on. This looks very, very much like fraudulent transaction. But the bank was paying no attention. Let's do that. And we can get rid of some of that. Sorry, I was just revising these slides. Sometimes when you revise slides, you make a few errors. The bank did not use. Let's just make sure we have no confusions in this case. So the bank wasn't following its procedures. Well, nobody was paying attention. Nobody monitored. Nobody was looking at the risk scoring system. So you've got this system going alert, danger, 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 and nobody's listening to it. It's nobody's job to monitor it. And so they could, right? But they just didn't. As you see the court explaining, they could, but they just didn't. Now that is just classic negligence. That is just classic negligence. And if you're teaching first-year students in law school in the JD program about negligence, one of the examples you give them is a business set its own standard for reasonable behavior, which the bank did, right? The bank said, here's our security system and here's how we plan to catch fraudulent transactions and stop them. So it set that standard for itself, and then it didn't meet its own standard. Not just didn't meet its own standard, didn't even try, right? That's negligent. That is negligent. And that's what the court said, right? I quoted from the court's discussion. They refer to Ocean Bank because by Ocean Bank was the original bank. By the time of this litigation, Ocean Bank had been acquired by People's United Bank. So, and so they didn't. With the court, the court says, if they hold, taking it all together, right? They hold not commercially reasonable. Okay, so So that's background for us, right? We want to see how we get to the contract issue. Well, so just to review, right? So they're clearly fraudulent transactions. The commercial statutes make the bank not, if the bank's procedures are reasonable, it's not liable. But if it's not reasonable, then it can be liable. And the court holds the system was not commercially reasonable. So you'd figure, gee, PATCA wins. The bank is liable, they have to pay. But as you see on the slide, there's a but. And the court says, that right after this, the court says, the but is, it is unclear what, if any, obligations a commercial customer has when the bank's security system is found to be commercially unreasonable. And that's all they say. Look, initially, you read that, like, oh, what? I mean, so you read the whole case, and you figure PATCO wins. And then all of a sudden, you read this, and then they don't decide that question. They said, well, we hold the systems commercially unreasonable, but People's United Bank didn't proceed with commercial reasonableness. They're unreasonable. You figure they should win, but the court says not so clear, and then they stop talking. But why? And the reason is the exculpatory clause in the contract. Here's what it says. The contract with Ocean Bank, People's United Bank, right, said that the bank was liable only for gross negligence, and it limited that liability to 6 months of fees. They said, we're not liable for ordinary negligence, this for really, really, really awful negligence. And as bad as what they did was, it's not gross negligence, they were just ordinarily negligent. So the exculpatory clause says, if we're just ordinarily negligent, not our problem, it's your problem, right? Because we're not liable for ordinary negligence. So that's the question. So even though they were unreasonable, right, the exculpatory clause says, not our problem. And this brings us to our contract question. Can you do that can you do that in a contract, especially in a contract with a consumer that you know the consumer does not read? There's some likelihood that PATCO, a business, read its contract with Ocean Bank or to become People's United Bank. I actually doubt it, but that they may have. But we have similar clauses in all the contracts we enter, both offline and online. And as we discussed last time, we don't read them. I certainly don't read them. Most people don't read them. Can you do this? And the answer is yes. The general rule is an exculpatory clause is enforceable if it's reasonable. Right? A reasonable, like if it's not unreasonable, it must be clear and understandable. The party, the releasing party, that's PATCO in this case, the party saying, I understand you're not liable, must understand what they're doing. They have to understand the risk they're letting the other party out of. And there must be no unacceptable disparity in bargaining power. You can't have one really powerful side unacceptably exerting its power to get the other side to enter the clause, and it must not contravene public policy. Within these limits, you can do it, right? So People's United Bank illustrates the public policy issue, right, which is relevant to whether our clause is enforceable. The e-banking clause, this clause may very well not be enforceable, right, for People's United Bank. As I say, the court never addresses that question, but it may not be, right? Because you look for public policy, where do you look, right? An ideal spot is in statutes. Statutes often articulate the reasons behind why they were drafted and adopted. And the UCC does that. They have a long discussion of how they got to the conclusion that banks should be liable for fraudulent transfers if and only if their procedures were unreasonable. And I just put in some of the discussion in the slides right? So you can see in the draft, you have, look, we looked a lot at this. There are a lot of competing interests that we considered. You see that up here? A lot of competing interests we considered. And we came to the conclusion that our rules are a good balance of those interests. So for the court, that's a strong statement of public policy. Look, we thought this through a lot. And we decided that the best way to balance the interest, all the competing interest here, is to have the bank liable if and only if it's unreasonable. So the question is, can the exculpatory clause changes that? But then the point of this clause is to change that balance. And given the strong public policy in favor of that balance, it's likely that if the court ever got to this issue, they would hold the clause unenforceable. Right? But the court, as I said, does not address that question, and we can assume that the case settled and after this, right? Because the court's decision suggests to both sides they have liability. Right? Patco was negligent in letting themselves get hacked. Right? The bank cannot escape liability through the exculpatory clause. Both sides may face some liability. In that kind of situation, the case probably settled and didn't spend any more time and effort and money on trial. But that's our illustration of exculpatory clauses. I thought it good to start with one case to show you how the exculpatory clause, how one of these clauses works in action. Now, the banking case was a little complicated. I hope that it wasn't too difficult to follow, but I like us to see at least one of these clauses in action and to see how it fits in with other statutes and how it works. So this was the exculpatory clause, no liability for negligence. And again, that is the law on those. The answer is yes, you can have them. As long as they're reasonable, right? And you think you're not hiding anything, it's clear and understandable. The other party gets it, understands what they're doing. There's no one side not forcing the other into it, and it's not inconsistent with public policy, which I said is probably the problem for People's United Bank. And so we looked at exculpatory clauses, we got indemnity clauses, and waivers or limitation of liability. And we'll take a brief look at those. Indemnity clauses require a person to bear the cost of any damages another person is held liable for, which another person is held liable. I'm very familiar with those. They're standard in book publishing contracts. Every book publishing contract I've had signed has one, because it says, gee, if you defame anybody or you commit copyright infringement or trademark infringement, right, and we, the publisher, get sued as the publisher, we'll have to pay off the judgment if we lose, and then you agree to pay us off for how much we had to pay out. That's the indemnity clause. If we have to pay out money, you compensate us, you give us back the money we paid out. In other words, that's what indemnify is. You indemnify us, right, against the loss. Yeah, and then we got waivers and limitations of liability. Here's the New York Times indemnity clause. As I said, it's easier in the world we live in to pick examples off for online contracting. So this is the New York Times online, but as I said, our offline contracts have the same clauses. For example, the publishing contracts I just said, those are all sent on paper. So you can see that, just to show you that they're an example of the clause, right? And the very broad one, right? You indemnify them for any claim of breach by you or any user of your account of these terms of service or foregoing representation, warranties, and covenants. And so if we get in trouble, we, the New York Times, get in trouble for something you do and we have to pay for it, then you have to pay us the same amount. That is exact. And so that's what they all say, right? Same rule. What's the law on those? The law on those is exactly the same as exculpatory clauses. It's just the same, right? Indemnity and exculpatory clauses, same rule. So yes, you can have those too. And what about waivers of liability? Here's the waiver of liability in Amazon's contract. Amazon will not be liable for any damages of any sort arising from the use of any Amazon service, or from any information, content, materials, products, including software or other services, including on or otherwise made available to you through Amazon service. So if anything goes wrong on Amazon, Amazon's not liable, right? That allocates the risk of using Amazon to us, to you, the user, to the users, and not to Amazon. What can you do on those? The answer, yes, you can have those. Look at the contracts you've entered. I guarantee you there's a waiver in there and also a limitation of liability. There will be something that says, we're not liable for our negligence, and to the extent we are liable, we only owe you this much money. We saw that in People's United Bank, right? We won't be liable for gross negligence. We'll only be liable for gross negligence, not liable for any ordinary negligence. And to the extent we're liable for gross negligence, we'll only pay you 6 months service fees. The only pay you 6 months service fees is the limitation on liability, right? That's the most liability we'll have. So you can't disclaim consequential or consequential indirect damages generally may be waived. You do, so I breached the contract, or I commit a tort, and then there are damages that follow from my breach of contract or my tort that you sustain, right? Those I can waive. The direct damages, the damages tied closely to my breach of contract or tort, I can't waive, but the stuff that follows then from it, I can. Intentional, reckless or intentional action, I can't waive, and liability for a defective product, I cannot waive, right? So there are limitations. We don't need to worry too much about the limitations. What matters for us is, yes, you can do it. And basically, you can waive your the consequences of your negligence. You can waive damage for that. And if you read the clauses that are actually written like Amazon's, they're written much more broadly, right? To get the maximum possible protection for the business. Yep, you can do this too. So what should we conclude? Because businesses can do it. That's good news for the business. And if we're lawyers for business, that's good news for us. But as consumers, and perhaps lawyers for consumers, not such good news, right? Because the rules limit the enforceability of the clauses. And that gives you some protection if you go to court, right, as a consumer. And a problem if you go to court as the business. But what about consumers entering contracts? How do they know the terms are fair? How many of us have you ever been to court on a consumer contract, or even to court on a business contract? Right? In consumer contracting, it's quite rare to go to court unless it's a class action. And even in business contracting, litigation is actually rare. Right? Renegotiation is the rule to avoid the expense of litigation. So think of us, when we think of us as consumers entering our contracts, right? How do we know that the terms are fair? How do we know that the terms are appropriately limited? So we see, so far, we haven't answered that question, and I don't think we get a terribly good answer to that question for quite some time. And that's one of our puzzles. But as we work our way through, we're working our way through offline contracting to see what kinds of protections are put in it to limit the terms that can be put in to avoid businesses taking advantage of consumers in contracts the businesses know the consumers won't read. And so here are our first set of limitations in our rules about these types of clauses. And while they give us something, they don't give us that much as consumers. They're actually rather favorable to the businesses, and I think intentionally so. All right, let's wrap this video up. We will, next topic, we'll keep working our way through our doctrines to get our picture of offline, to get our picture of offline contracting. And then we'll turn to online contracting and notice the changes and refinements that have gone on there. As before, any questions, happy if you email me, let me know, right? One way to have a little more interaction during the pandemic when I can't be there in person is to use email so that we can talk to each other if you have questions. All right, see you in the next video.